Now, let's look at the mortgage that's included in the materials. Now, again, I want you to be following along and looking at your mortgage as well, but just so we can kind of figure out what's involved. If you look at this mortgage, as we talked about, it shows Stockton Turner. Now, what is a mortgage? And, people always say, well, they think of a mortgage and the promissory note is the same thing. But the promissory note is the debt instrument. So this is where you say, I'm going to pay you back the money you gave me, $500,000. The mortgage is what secures the payment. So let's say there was no mortgage, but you just signed the promissory note. Then if you don't pay, they can sue you and they could try and do things to you, but they couldn't take your house. And so the mortgage is that thing, what we call a security instrument, that allows them to take the house from you. All right, so there's two different documents. The promissory note is the debt. The mortgage is the thing that allows them to do something about you not making the payments. All right. So in this case, we already identified Stockton Turner was the promissory note, the lender. In this case, you can see they hold the mortgage. So we know that the plaintiff is not Stockton Turner. We know that they had transferred at least once. And so the question is, how do they enforce the mortgage? So let's say they have the promissory note, but they don't have the mortgage. So what if they have the endorsements, but they didn't assign the mortgage? And you assign a mortgage, you don't endorse it like a promissory note. Now I'll tell you, there's a lot of cases out there that says that the promissory note goes with the mortgage. And I think that's bull, because the mortgage companies split the documents. And there's a whole different thing that we'll talk about somewhere down the road, but not here. But for now, in general, a mortgage must be assigned. They should have an assignment of mortgage to the plaintiff so that the plaintiff can actually take your house from you. If they don't have that, all they have is a defaulted debt instrument, which doesn't necessarily allow them to take the house from you. Okay, so we look at the mortgage. Now, what you're looking for is, do they have an assignment of the mortgage? So that would typically be in a separate document. So if you look at the next document, and then I'm going to come back to the mortgage, I want to look at one more thing. If you look at the next document, it has assignment of mortgage. And so yes, they do have an assignment of mortgage. And that by its terms would appear to qualify to give them what they need. But I want to show you something about this assignment. And this is something that we'll discuss somewhere down the road in discovery, and maybe when we get into the motion for summary judgment and maybe the trial. There's some problems, I think, with this assignment. If you look at the assignment, you'll see that it was recorded and developed by the attorney who brought the foreclosure action as attorney in fact for a defunct mortgage company. Now, the mortgage company, I know for a fact, was out of business several years before they brought this foreclosure. So the question becomes, how can the law firm become the attorney in fact for a defunct mortgage? I think they got to have some proof of that. I think there has to be some documentation that shows you how to do it. But I'll tell you, in reality, many of the mill foreclosure firms, they just created this stuff to make the foreclosure go through. In fact, we were just talking about just recently, this might date these videos a little bit, but just recently a major law firm was shut down for creating documents, doing robo-signing in support of the foreclosures. So this is an issue in this particular case. So yes, there is an assignment, so you can't raise it in the motion to dismiss, which we'll talk about later. But we're going to come back to this when we get into the questions of proof of the thing itself. And we're probably going to look at it when we talk about the motion for summary judgment and the trial. All right, so yes, they do have an assignment. If there's no assignment in your mortgage, if there's not a document that says assignment of mortgage and it's someone different is the plaintiff, then you probably have something that we can complain about in the motion to dismiss, which we're going to talk about in the next segment. Now, before we go on though, I want you to go back to paragraph 22 of this mortgage, and it says in here, acceleration remedies. Okay, now paragraph 22 is a standard paragraph in most mortgages. There are some non-standard mortgages. FHA doesn't have it, but there are some in general. I would put it at 80% of the mortgages, if not higher, have a paragraph 22 in them. And what's acceleration? Well, all right, your mortgage, your promissory note is a month-by-month obligation. And you may be several months behind right now, you may be a year behind, but the rest of the payments aren't due yet. You may have 25, 30 years of payments left that haven't come up. So they can't really sue you because they're not due. And so for now, they have to only sue you for the payments that you've missed, which it doesn't really work for them. And so an acceleration allows them to say, you know what, you defaulted, the whole thing is due. So even though by the terms of the agreement, you had another 25 years to do it, that's off. Now you owe everything. So it's what we call acceleration. You know, and it has to be that way. Otherwise, they could never really foreclose, and it'd be a whole nightmare. It's a problem. So acceleration, typically thing, right? So that's what acceleration is. Most often, and certainly in paragraph 22 cases, the bank is required to give you at least 30 days that they're going to accelerate the balance due before they can file the foreclosure. All right? Now, I'll tell you in reality, almost always they do that, and they've probably given you a year notice that they're going to do that. But I believe that they have an obligation to put that notice in the complaint. It's what we call a condition precedent, which means that it's a condition that must be satisfied prior to them filing the foreclosure. Now, the case law actually says they have to do it by summary judgment. But you know what? I'm going to throw it in there in motion to dismiss. If I got nothing else, a lot of times this allows me to do the motion to dismiss. Why do I care about doing a motion to dismiss? Because it buys time. Buys time in your house. And that's what we're looking for. So that's something that I can argue about. Say, look, you know what? They didn't give me the acceleration notice within 30 days like they're required to. So I want you to go back and look in your mortgage and see if there's a paragraph 22. Sometimes if it's a non-standard mortgage, there may be an acceleration clause somewhere else, paragraph 21, paragraph 23, but look for acceleration remedies and see if it's required that they give you notice, typically 30 days. Almost all mortgages have this in there. FHAs, again, and some non-standard type mortgages don't, but I want you to look at that because if you do, then we got something else we can fight, okay? So in the mortgage, the two things we're looking for is there an assignment of the mortgage? And I'll tell you, very often they don't include the assignment of the mortgage. They may actually have it. They may have even recorded it. But for some bizarre reason, they don't attach it to the complaint. That gives you something to fight. And second, do they have an acceleration requirement, paragraph 22? And if they do, and they didn't list anything showing that they sent notice in the complaint, that's something else we're going to look at.